Welcome, everyone. I'm going to go ahead and get us started. Thank you for joining us for this last session of the day. I'm Judge Ann Levinson, a former judge, and I am happy to be moderating this session. This is a panel discussion on the evolving landscape for legal issues affecting LGBTQ Americans. I want to thank Chief Judge Tom Martin and also the wonderful Conference Planning Committee have been terrific for inviting us to come speak and for asking us in particular to talk about this topic. Let me begin by saying that when we originally conceived of this panel and planned it in the fall, our focus was going to be on providing you an overview of how legal rights and protections for LGBTQ individuals and families have evolved and the progress made in particular in the last several years. We were going to build from the Supreme Court decision affirming the rights of same-sex couples to marry, and then we were going to share with you and lay out the remaining issues critical to achieving full legal and social equality. But to be frank, in the weeks since November 8th, the legal landscape for LGBTQ individuals and families has changed dramatically. As with immigration and environmental protection, as with voting rights, criminal justice reform, health care, and reproductive freedom, and so many other fundamentally important issues, what lies ahead now portends to be a dramatically different future for LGBTQ Americans. State laws, federal laws, agency interpretations, and pending litigation affecting the LGBT community are literally hanging in the balance. Hard-fought rights that many of us thought were secured may be rolled back or vitiated in myriad ways. As our speakers will describe for you, we are all collectively girding against a wave of literally hundreds of bills in state legislatures seeking to enable anti-LGBT discrimination in the name of what's often referred to as, quote, religious freedom, particularly detrimental to LGBT individuals in states that do not have anti-discrimination protections. Bills such as one that would, for example, allow refusal to place children with foster or adoptive families based on the agency's religious beliefs, or bills allowing licensed counselors and therapists to refuse to treat patients based on the therapist's religious beliefs. It seems impossible for many of us to believe that in this day and age we will have to go back and relitigate the questions of whether a business or nonprofit that provides service in the public realm must in fact serve all people in a non-discriminatory manner, or whether a local government can be precluded from passing laws prohibiting discrimination in employment, housing, public accommodations, or whether gay teenagers can be forced by their parents to undergo so-called conversion therapy, and whether a federal contractor would once again be allowed to refuse to hire someone simply because she's a lesbian. So this is not going to be a dry intellectual debate of legal theory. What we're going to be talking about this afternoon is affecting lives in real ways. Many of you may not know that in the weeks since November 8th, families and parents all across the country, all across the states, have been rushing to lawyers, to the Social Security Administration, to their medical providers, and to their children's schools to do whatever they can to protect themselves. Parents with transgender children are particularly fearful for their safety. LGBTQ Americans of all ages feel at risk and vulnerable, wondering when and in what ways what was already a patchwork of legal protections across the states might be pulled out from under them. So we've brought together three panelists who know this landscape as well as anyone to give you their best thinking about what lies ahead. I've asked each of them to provide a 15-minute overview, and then I'll give them some follow-up questions, and then we'll open it up to all of you for whatever you'd like to ask. And our ground rule is that anything is okay to ask, and we're all here to learn. So first up will be Amy Whelan, who's a senior staff attorney with the National Center for Lesbian Rights. That's a nonprofit public interest law firm that was founded back in 1977 to advocate for equitable public policy affecting the LGBTQ community. They do impact litigation, public policy advocacy, public education, and collaborate with other social justice organizations. They provide direct legal services and advance legal and human rights for LGBTQ people and their families across the country. Amy in particular litigates complex civil cases regarding marriage equality, employment discrimination, Title IX, family law, access to health care, prisoners' civil rights, the First Amendment, and other constitutional matters. And in organizing this panel, I learned that both Amy and I graduated from Northeastern University School of Law, albeit I was a few years earlier than she was. And Amy's going to provide for us today an overview of recent and current litigation in federal and state courts and what issues might in fact be headed to the U.S. Supreme Court. Then next up will be Kirk Fordham, who has a long history of strategic engagement and organizing at both the state and federal level. Kirk's currently a public affairs consultant, and he's the former executive director of Gill Action, which is a national political organization headquartered in Colorado, founded to secure equal rights for all Americans, regardless of sexual orientation and gender expression. Before that, he was the chief executive officer of the Evergreen Foundation. He's a veteran political strategist. He's got a strong bipartisan track record, served for 14 years as chief of staff and senior legislative advisor on Capitol Hill for 3 different members of Congress. He's going to describe the laws being proposed, debated, and voted on in state houses across the country and in Congress, including the so-called Religious Freedom Restoration Act and the also so-called First Amendment Defense Act. And then Tammy Baker will clean up. She's the managing principal in the Birmingham, Alabama office of Jackson Lewis PC. She's been recognized many times as one of the top lawyers in Alabama. Tammy has experience in all aspects of workplace law, including multi-plaintiff and class action litigation. She regularly advises employers on complex issues, including compliance with FMLA and other employment laws, and she lectures frequently on employment-related topics. She's represented a wide variety of companies, including nationally known retailers and manufacturers, national and regional banking institutions, government defense contractors, universities, and healthcare providers. Tammy's going to walk us through the fluid state of employment law affecting LGBTQ individuals and how important agency rulings are and what employers should be expecting and anticipating in the months ahead. So let me ask Amy to come up, and then we'll do these presentations, and then we'll do some questions. Amy.
Okay, hi everybody. Thank you so much for having me here. I was voted as the person to get us on the same page about terms we're going to be using today. So I'm going to very quickly do that right now, although we also handed out a worksheet to people that explains these terms and defines some of them, and we'll give you a little more detail, but I'm going to very, very quickly go through a few of them because they're terms you'll hear us use today. These are the ones I'm going to go through one by one. First, you may hear us talk about sex assigned at birth, which basically often we refer to it related to transgender people, but it's essentially happens to all of us. We're born as tiny babies, usually in a hospital, and somebody looks at us and says, okay, that's a boy or a girl based on a cursory view of our bodies. Next is gender identity. Again, it's also often talked about today related to transgender people, but actually everybody, including every person in this room, has a gender identity, and it's our own personal internal sense of being female, male, or another gender. Everyone has it. And then there's gender expression. So our behavior or appearance, the way that we dress, the way that our voice sounds, our intonations, essentially it defines the social cues that we all give to one another as we interact in this world in society. Next is sexual orientation. Basically refers to a person's sexual desires, so as distinct from your gender identity, it's who you might be attracted to in a romantic way. Next is transgender. We like to just specify that it's an adjective. People, when you say the term transgenders, it's not usually an acceptable way to refer to it. It's an adjective that describes a person whose gender identity differs from their sex assigned at birth. So a transgender woman, for instance, is someone who was assigned the male sex at birth, but her gender identity is female. She typically lives her life as a female on an everyday basis. And the same thing, a transgender man was assigned female at birth, but has a male gender identity, and he identifies and lives as a male typically on a daily basis. And then cisgender, which is not a term I personally use, and we don't really like this term, but you might hear it, and it basically refers to a person whose gender identity does match their sex assigned at birth. So essentially just a non-transgender person. So as I said before, sexual orientation is distinct from gender identity. Transgender people have a variety of sexual orientations, and there's not necessarily a correlation at all. They're two distinct topics. Now, what does transitioning genders mean? People often talk about a social transition first. If people have had a coworker who has transitioned or a family member, you might see that the first steps would be that that person might change their name. They might change the pronouns that they're using to align with their gender identity. They might start presenting socially in a different way. They might wear different clothes. They might use a different hairstyle. They might start wearing makeup or stop wearing makeup. So essentially, again, it's the way that they might transition in their everyday interactions in society. And then there is also medical transition. This often includes taking hormones. It may also involve surgery, but it's important to note that many transgender people don't engage in a medical transition either because they may not want to or because they don't have access to that medical care, either because they don't have access to the service or because their insurance won't cover it. Okay. And again, there are terms, and if anybody has questions or wants to talk about them more, we're trying to leave time for that at the end. So I'm here to talk about current litigation, and I'm going to do something that is a little bit different from what I usually do, which is that I'm going to focus on kids. And I want to do that for two reasons. First, we often talk about LGBT people, and we refer to adults, but as we all know, we do not come into this world as fully formed adults. We come into this world as babies and then kids and young adults. And second, I think that many of the key cases that have happened recently or that are happening soon involve kids in different ways, whether it's LGBT kids in particular or whether it is kids who have LGBT parents. So I think it's a good way to focus the 15 minutes I have of discussion today. And so first I'm going to talk about some of the legal trends that we see related to LGBT people in our cases. And then I'm going to talk briefly about the ways that the policies based on those legal arguments affect LGBT kids or kids who have LGBT parents. In particular, we know from both evidence-based research and anecdotal research or evidence that LGBT kids who are rejected and ostracized at home, at school, by peers, in their communities, they are much more likely to do poorly in school, to experience homelessness, to be subjected to child welfare oversight, to be foster kids, or to engage in dangerous behaviors, including suicide. And when I say anecdotal information, I mean information that's not research-based, but it's based on information that we know from people who are with kids all day long. Teachers, social workers, coaches, people who interact with those kids on a daily basis and often in their professional lives. And then finally, I'm going to talk about 4 LGBT cases that demonstrate the legal trends I'm going to talk about toward LGBT people and that involve children in some way, including the recent marriage equality decision from the Supreme Court, a case that is currently pending before the US Supreme Court, a case NCLR, my office, recently filed in Utah against the State Board of Education and various local education boards, and an employment discrimination case. So first are legal trends. I'm only going to talk about 2. There are actually a lot, but these I think are kind of the most common. And the first one is that LGBT people are dangerous. And you see this in a variety of ways, and I'm going to talk about some examples from cases, but it actually goes back in history much longer than even recent cases. It goes back to the McCarthy era, which was, of course, the Red Scare, but also the Lavender Scare, when thousands of federal employees were losing their jobs, and there was a governmental purge of communists and queers from our federal government. And then in 1952, homosexuality was classified as a severe mental disorder. That was not removed until the early 1970s. We saw a bunch of ballot measures. They kind of came in waves. The first wave, I think, actually, I mean, certainly the 1950s, but the 1970s was a big wave of anti-LGBT initiatives and legislations in the country, including the Briggs Initiative, which was in California, where I now live, which essentially would have barred LGBT teachers from teaching in public schools. And of course, in the marriage cases, and I'm going to talk about those because NCLR personally handled many of the marriage cases across the country, but there were many arguments about how LGBT people were bad parents or not as good parents as non-LGBT parents. And this is also a theme that we're seeing in the bathroom cases, not just related to kids, but also related to adults. This sort of underlying theme that transgender people are dangerous, that if we do this, danger is going to ensue in bathrooms and women are going to be unsafe. The second trend is a little more, it's kind of the opposite, but I feel like it's related, and that is that LGBT people do not exist. So for instance, in the marriage cases, we saw this when there were arguments about what is the level of scrutiny that should apply for the equal protection claims that relate to LGBT people. And one of the parts of that test for people who do constitutional litigation is whether it's immutable, whether or not the characteristic that you're talking about is immutable. And of course, the states argued that it wasn't, that you're not born gay, and that actually it's just a pathology or it's the result of trauma. And so those are the kinds of arguments we see. This is also the basis for conversion therapy and the theory of conversion therapy. Conversion therapy is something that was used a lot in the 1950s and 60s when gay people were committed involuntarily to mental hospitals because of the 1952 designation of homosexuality as a serious mental illness. And it's still practiced today. And in fact, there are a couple of states that have barred licensed therapists from performing conversion therapy. So this is therapy that's intended to stop someone from being gay. And there are several states that have now passed laws that prohibit licensed clinicians from performing or attempting to perform conversion therapy on minors. And so far, those laws have been upheld by higher courts. So just briefly, I want to talk a little bit about some of the data that we know about the impact on kids and young adults of these policies and what I think are actually these themes that we see in the legal arguments. And so there's kind of two primary places where kids are or spend their time during a day, in their family or in their home or at school. And so the rejection that kids feel in those two places are particularly important and acute. And we know that kids who experience family rejection are 8.4 times more likely to attempt suicide, much more likely to have high levels of depression, and almost 3.5 times more likely to use illegal drugs. In the same sense, bullying at schools correlates with higher rates of truancy, depression, low self-esteem, and lower grades. Even though LGBTQ youth, it's hard to sort of estimate the number, but it's likely not higher than 10% of the overall population, and yet LGBT youth make up to 40% of homeless youth, and that's in large part due to family rejection. They're also very overrepresented in the juvenile justice system, and they're two times two times more likely to have experienced child abuse, foster care placement, and homelessness than their peers who are also in those juvenile facilities. They're also much, much, much more likely to experience sexual abuse in those juvenile justice facilities. So the good news about schools is that we know that when kids are supported in schools, they are more likely to graduate, they're more likely to go on to college or even graduate school. We know that kids at schools that have gay-straight alliances, which are student groups that are intended to support LGBT kids, and they're often formed by both LGBT kids and non-LGBT kids. Those kids report higher levels of safety and well-being, and that schools that have anti-bullying policies that are specific about LGBT people, so they mention that specifically, report higher levels of teacher intervention, they feel safer, and they experience less harassment and violence. We also know the good news about families, which is that it's now beyond dispute that young people need their families to navigate adolescence and especially adolescence. And we also know that the prior instinct, which was a very well-intentioned instinct, I think, of child welfare agencies to remove kids from rejecting families, we now know that that actually does not work and can be very harmful. And that, in fact, even highly rejecting parents, including parents who initially reject their kids based on deeply held religious beliefs, most of those parents change that behavior if they are told about the risks that it poses to their children. And this makes sense. Most people care about their children, don't want to subject them to harm, and so once they understand that, they actually do change their ways, even if they're deeply religious beliefs. So the first case I want to talk about is, I'm actually going to talk about the Obergefell case, which is the marriage decision that came out of the Supreme Court. There were about 70 cases across the country, I think more than 70 cases across the country. I think a marriage case was filed in every state eventually. And sort of a slew of decisions were starting to come out all over the country from federal judges, state court judges, basically striking down these marriage bans. Now, one of the earlier cases was out of Utah, Lotta versus Otter. And this is one of the plaintiff couples in the case. This was one of NCLR's cases. And this is an example of arguments about LGBT people being bad. And this is directly from one of the governor's briefs in the case. And you can sort of read it here, but it talks about how they had to figure out a way to describe marriage that didn't apply to gay people. And so they came up with this phrase, because marriage's man-woman meaning provides materially and even uniquely multiple social benefits, to suppress that meaning and replace it with the radically different genderless meaning is to create a grave risk to Idaho society. A genderless marriage regime will not produce those benefits, but rather be hostile to them. So there's a lot of like really scary language, like don't these people look really scary? I mean, like, that they're a grave risk to society, that they could, I mean, there's like sort of these arguments like the social fabric that we all live in is gonna fall apart. It's hostile, it's a regime. So that was one example. And then this is just another example, but it's very similar, kind of their mantra: the marriage of any same-sex couple, just the opposite of the marriage of any man-woman couple, can only destroy rather than reinforce the source of the valuable teachings and practices Idaho rightly seeks to promote. This is directly from the governor's brief, and this is, I mean, truly an example. Like, the things that were said in these briefs, this was universal pretty much with the states that opposed these bans or tried to defend these bans. Now you can see that this did not go over well with the Supreme Court, and this is the majority decision part of it that was written by Justice Kennedy, and he very eloquently talked about the effect on families. And what you can sort of tell from this is that the connection between the values of marriage for straight people and why gay people getting married would somehow put that in danger just wasn't connecting for him. And so he talked about without the recognition, stability, and predictability marriage offers, their children suffer the stigma of knowing their families are somehow lesser. The marriage laws at issue here thus harm and humiliate the children of same-sex couples. So that's what he cared about. That was what his focus was. There's a lot of language in his decision about the dignity of all couples, and that in a civil society, that's what we must uphold. Another example of something that I thought was a beautiful part of his decision is that he said, were the court to uphold the challenge laws as constitutional, it would teach the nation that these laws are in accord with our society's most basic compact. And in other words, our social contract that we all have with each other, that we agree to have living in a democratic society that is full of a diverse group of people, not just based on race or nationality, but also religion and sexual orientation and a variety of other things. Next, I'm going to just briefly talk about this case, which is currently pending at the U.S. Supreme Court. This is Gavin Grimm's case against Gloucester County School Board in Virginia. This is a picture of Gavin. He's the plaintiff in the case. Essentially, he is a transgender boy. He was diagnosed with gender dysphoria and started using the boys' restroom. He used it for about 2 months, and then there were complaints that were made by parents, so the school board basically adopted a policy saying that transgender kids could not use the bathroom in accordance with their gender identity and that they had to use a segregated restroom somewhere else. So the ACLU filed suit, and they relied in part on the position of the U.S. Department of Education, which said that, of course, schools can have segregated bathrooms for boys and girls as they have for eternity, but that means that they have to provide access to those bathrooms in accordance with gender identity for transgender kids. And so there are 2 questions right now pending with the U.S. Supreme Court. One is whether that guidance from the Department of Education is entitled to deference. We can all see that maybe that guidance is about to probably be retracted, so that question may go away. But the other question, which the court may reach, which is very important, including for cases that Tammy is going to talk about too, is whether, regardless of that guidance, the sex discrimination prohibition in Title IX protects transgender students. So this is just an example from the Virginia brief about how I use this as an example that transgender people don't exist. And so this was what they said in one of their briefs to the Supreme Court. Gender identity means individuals' innate sense of being male or female, which may differ from the sex they were assigned at birth. Making access to sex-separated facilities turn on this elusive concept would lead to obvious and intractable problems of administration. So, in other words, transgender people don't really exist. It's so elusive. How could you even know? That doesn't make sense. This is unworkable. Please, court, just don't do anything. And in fact, it's granted cert, and this is from their opening brief to the Supreme Court. And in fact, many public schools enforce this exact policy, including something that was in the materials from the Arcadia School District in California. Many universities and colleges enforce this. Many employers, many state athletic associations. The NCAA has a policy about transgender athletes, both with respect to playing on sports and also access to facilities that all follow this concept, or all are able to delineate between transgender kids and non-transgender kids without problem. The next case I want to briefly talk about is a case we recently filed against the Utah State Board of Education. Many people don't know this, but Utah and 7 other states ban positive speech about LGBT people in public schools. So essentially, and this applies to curricula, classroom and student clubs, and it means that teachers cannot talk about LGBT people in a positive light. So if there's a kid who has LGBT parents, they can't talk about that. One of the plaintiffs in our case wanted to do a report on his uncle who was gay. He was told he couldn't do that. And the 1996 sponsor of this bill, which is quite old, it was part of a spate of anti-LGBT legislation that happened in the mid-90s, said that it was aimed at keeping avowed homosexuals out of public schools. And so we filed a complaint, it's pending, and this was one of the statements on the Senate floor to support the bill, which essentially is that groups whose very existence implies that homosexuality is a genuine element of personal identity will, in the short run and the long run, inadvertently harm the young people they wish to help. So in other words, telling LGBT people that, or kids, that it's okay to be gay, which is in fact the position of every major medical and mental health association in this country, is not okay and is prohibited. And this is true even though the Utah State Board of Education has a bullying prevention publication that recognizes the risks that I talked about before to kids of having policies like this, that they face an increased risk, including even of suicide, when they are not supported by their parents or their schools or their communities. So right now we have a motion for preliminary injunction that we filed last week that's pending before the court. And this was just a little quote from our brief that quotes the Cruzan case, which is one of my favorite statements from that case. But basically, I don't need to read it other than that it points out that the policy treats gay people essentially as the only group of people whose existence is deemed so shameful, immoral, or controversial that any supportive discussion of this group must be expressly prohibited. The last case I'm going to talk about is just really quickly is called Broussard versus Tower Loan. It doesn't, it doesn't really involve a kid, although this was our client, Tristan Broussard. In my mind, he's kind of a kid. I think he was 20 years old when this happened to him. He basically, his story illustrates what I was talking about the harms to LGBT kids. He was rejected by his family when he came out as transgender. He was kicked out of his house. He's basically living in poverty. And he got a job at Tower Loan Bank, which is located in, I think, 5 southern states. And he went in, he was interviewed. They thought he was a man when they interviewed him. They thought he was a man when they hired him. As part of his application, he had to give his government ID document, which was his driver's license, which listed an F on it for female instead of male. And later, after he was hired, when they figured this out, they went to him and they said, "What's going on? Why is this F on your license?" And he said, "I'm a transgender man." He explained what that meant. He said he was taking hormones, and they said, "Do you want us to talk to you do you want us to use male pronouns or female pronouns?" And he said, "I'm a man, please use male pronouns." And they said, "Okay, no problem." And then they reported that to the headquarters office. And the headquarters office of Tower Loan sent a vice president down to speak with Tristan, brought him into a back room, and gave him a statement that he wanted Tristan to sign, which is right here. It said, "I understand that my preference to act and dress as male, despite having been born a female, is not something that will be in compliance with Tower Loan's personnel policies." So this was an example of, well, you say this thing about you that you're a transgender guy, but we don't actually think that that exists, and even if it does, it's definitely not okay with us. It's not going to comply with our policies. Tristan refused to sign this, and he was fired. And this actually it was not in court, it went to arbitration because there was a mandatory arbitration clause in his employment contract. And the arbitrator in Jackson, Mississippi found that he involuntarily resigned in order to escape an intolerable and illegal requirement imposed by the corporate office that he act and dress only as female. Okay, hand it over.
What was the remedy that the arbitrator imposed there?
he got damages. He didn't really want to get reappointed to his position.
It's a very dour note to transition on here, but
And Kirk.
so let me just say, I'm Kirk Fordham, and I will start by saying that I have been one of the beneficiaries of all these amazing legal rulings over the last many years. A couple of years ago, I was able to get married to my husband, Mike, after 25 years on our anniversary. And my parents were able to be there with his parents. They had never met, but they met at our wedding. And so that was pretty remarkable. And when we lived in Florida, we were able to adopt our two sons, Lucas and Levi, who, when we started the process, Florida had a ban on gay people adopting children. In the midst of that process, the ban was struck down, and so we were able to adopt as a couple. And those two kids are the delight of my life, and I'm getting 2 nights off of 5- and 6-year-old interruptions in the middle of the evening. So, we have here Congress in the states, a little update, and although it's always tempting to start in DC, in spite of the fact that the fate of the world seems to be hinging on the latest Twitter feed from the president, I think it makes a lot more sense to talk about the states, because really we expect a lot more action to happen in state capitals over the next year or two, partly because if you look at the agenda that Congress has ahead of them, Obamacare repeal and replace, tax reform, Supreme Court nominations, cabinet nominations, big budget battles, transportation bills. There's not a lot of days left on the calendar to do either pro or anti-LGBT legislation. So we're not expecting any real big debates on these things on the floor of the House or the Senate, but that's not to say that they still couldn't be quickly ushered through, especially on the House side, which has a more liberal calendar policy, and they can move things a lot more quickly based on their rules. And the other thing is that states are sort of laboratories for policy innovation. If you think about not just on these issues, but on a whole range of issues, whether it's healthcare, tort reform, state capitals tend to lead, and Congress talks a lot and holds hearings, and they sort of stir the coffee, and then eventually they get around to passing legislation. So the states are really where we expect to see most of the activity. So let's just think about what the central objective of the LGBT movement has been. It's really to ensure that all LGBT Americans are treated fairly and equally at work and in our communities. It's pretty basic. It's not radical. We sort of just want to be treated like everyone else. The kid that applied for the job at the bank wanted to do his job. So you think about that, and even though the movement started unofficially, you can look in history at a number of actions that took place throughout the United States history, but we sort of use 1969, the Stonewall riots, as the unofficial beginning of the LGBT movement, when the police raided the bar at 1 in the morning and 3 days of riots ensued. And then you went through a period of time where in the 70s, very progressive cities started adopting ordinances protecting LGBT people. And then you had pushback sort of manifested. You think about Anita Bryant in 1977 in Florida, where she successfully repealed the Miami-Dade non-discrimination ordinance. We moved from that phase, and then we really started talking a lot more about marriage. And after Wisconsin was the first state to adopt a non-discrimination law protecting private sector employees, you saw this flurry of activity that started on marriage again. It really started in Hawaii when the Supreme Court there ruled, opened the door to same-sex marriage. The voters quickly rejected it on the ballot that fall. And then anticipating a wave of same-sex marriage activity across the nation, Congress in 1996 passed the Defense of Marriage Act, which was signed into law by President Clinton and passed pretty overwhelmingly on a bipartisan basis. So you look, and people say to me today, they said, my gosh, when marriage was legalized by the Supreme Court just a couple of years ago, it happened so fast, it just happened in a matter of years. And I say, well, actually, it was a multiple number of decades that this unfolded. It's really only in the last years of that debate that people really started paying attention and that we started seeing progress. We spent a lot of, those of us that worked in the movement early on, spent a lot of time losing and, having very depressing election nights, as we saw multiple states across the country pass same-sex marriage bans and amending their constitution because our marriages were such a threat to our republic. So let's look at the states. I only have one slide in my presentation, so we're going to look at the map of the United States. And if you look at the current state of play, you can see that right now in 32 states, LGBT Americans are not fully protected from discrimination. And this map actually sort of looks like the Trump-Clinton map in some ways, with a few exceptions. Red states are actually the progressive states that have passed non-discrimination laws, including housing, workplace, and public accommodations protections. And they are all transgender inclusive. If you look at Wisconsin and New York, they were early adopters. They passed their laws early on, but they did not include transgender citizens in their states, and there are now efforts afoot in their state capitals to amend those. I should add New Hampshire too, where there's been a bill introduced in New Hampshire to amend that to include transgender Americans. Utah is the most recent state to pass a non-discrimination law, and you wouldn't expect Utah, of all places, to have adopted something so progressive, considering it's really one of the reddest states in the nation. And I spent a lot of time in Utah working with advocates in that state, with a lot of Republican legislators, the Mormon Church and their leadership. And I have to say, even though Utah isn't the model legislatively for us, it is a model for us on how we engage with our opponents. And I have to say it was one of the most civilized places I've ever worked and had conversations with people that disagreed with me. And I really think that the way that the conversation took place in Utah is really something that we should replicate in other states where we have to have these debates. But the difference with Utah and the others that are red is that they dropped public accommodations. Because the LDS Church is so intertwined with so many of their institutions, especially their universities and many of their businesses, a compromise was struck, not one that any of us in the movement would want to adopt anywhere else, that dropped public accommodations for now. And I think that's something that the state will come back to. But the guy that introduced and helped pass the bill is a guy named Senator Urquhart. He's from Southwest Utah, St. George, a gun-toting, Tea Party, Mormon Republican, very conservative guy that led the charge and convinced his colleagues that this was the right thing to do. And so now I think, I make the argument in other state capitals, if Utah can do this, so can Texas, so can Florida, so can other states, so can Kansas and Missouri. So let's talk about Kansas and Missouri. We're right in your backyard. I spent a lot of time working in Missouri over the last number of years. Right now you have no statewide non-discrimination law. In 2013, we were able to actually get a measure passed by the Senate on a 19-11 vote. A lot of Republicans supported it, had a lot of support from the business community on both ends of the state. But it literally passed in the final 15 minutes of the legislative session. They ran the language over to the House. The House refused to consider it in those final 15 minutes, and it died. And it really hasn't been reconsidered since then. There is a statewide non-discrimination policy for state employees. So Governor Nixon at the time enacted this through executive order, and that still applies currently under the new governor. You have 2 counties and 12 cities that currently have passed non-discrimination ordinances at the local level, and that has been a strategy of the movement in state after state to secure local protections in as many municipalities as you can, and then go to the state and say, look, employers would really prefer to deal with one employment office for complaints as opposed to trying to figure out how to handle 12 different county ordinances and how they deal with complaints in each of those counties. It's much more efficient for employers, and frankly, it's just a better law to have a statewide protection, and it has more teeth because you can go to the state courts. In 15, you might remember Springfield, Missouri. Their city council passed a non-discrimination ordinance. It was placed on the ballot shortly thereafter, and the voters narrowly, by 51-49 margin, rejected it. So Springfield had protections, and then they removed those at the will of the voters. You have a pretty strong state hate crimes bill or law. And last year, in 16, you probably recall the debate over SJR 239. Essentially, it was an effort to put before the voters a constitutional amendment that would allow very broad and gaping loopholes for folks to use religious excuses to discriminate to folks, to prevent people from serving LGBT people based on their deeply held religious beliefs. It passed the Senate, and then it failed in the Emerging Issues Committee. On a 6-6 vote, 3 Republican lawmakers joined 3 Democrats and killed that, and it never came up again, and I'm not expecting it to return this session. Kansas, on the other side of the border, there were really no protections of any kind in Kansas in the private sector or for state employees. Only 2 cities, Lawrence and Roland Park, have municipal ordinances. And then, oh, did you have a third? Congratulations. I rely on the Freedom for All Americans website, and it hasn't been updated, so progress. And you have a hate crimes law protecting lesbian, gay, and bisexual folks, but not transgender folks. And then your laws on adoption are fairly mixed. Sometimes it depends on the judge, but you have a mix of laws there. So let's shift to the federal level, because this week we saw a lot of discussion, mainly on Twitter, and there was a lot of discussion and rumor going around about what President Trump might do with the executive orders that President Obama had executed a couple of years ago. There were 2 of them, really, that were the focus of all the attention. One was one that added sexual orientation and gender identity to the protections provided for federal employees. And another was more expansive. It actually applied to federal contractors. So if you were knitting sleeping bags for the Army and your company wanted to keep that contract, they actually had to have an internal policy that said, we don't discriminate on the basis of sexual orientation or gender identity. So it's a very simple internal HR policy to comply with. All they had to do is demonstrate that they had it in place and advertise that to their employees. And it's really significant because it covers about 20% of employees in the United States. So you're talking about 28 million workers that are employed by federal contractors. So that's a pretty big deal. So there's rumors going around Washington for quite a while earlier this week that Trump was about to either overturn these or sign executive orders that were religious freedom-like orders that allowed for pretty gaping exemptions to those executive orders. And in the end, we don't know how it all unfolded. We have some rumor and suspicion on how it unfolded, but he issued a statement saying that he would, in fact, continue to enforce those 2 executive orders, and that's a pretty big deal. We're not certain that that's the last word we're going to see from this administration on that subject, but it is a sign of hope that there may be reason for optimism. In Congress, the legislation that you're most likely to see some action on is really surrounding the First Amendment Defense Act. It is a RFRA-like measure, similar to those that have been considered in North Carolina and many other states. We expect that that will be introduced in both chambers. It's very possible it could move through the House at some point over the course of the next couple of years. However, I think we're pretty confident that there are a number of Republican senators that are already firmly opposed to that measure, and based on the rules of the Senate, I think it would be very difficult for them to, 1, either consider it, or 2, actually get even a simple majority to pass a FATA-like measure. Yeah, basically, and I know we have about 2 or 3 minutes left, I'm going to read what the FATA says it does in very short. It says it would prohibit the federal government from taking discriminatory action against any business or person that discriminates against LGBTQ people. The act distinctly aims to protect the right of all entities to refuse service to LGBTQ people based on 2 sets of beliefs, and these are the 2. Marriage is or should be recognized as the union of 1 man and 1 woman, or 2, sexual relations are properly reserved to such a marriage. So it would allow federal employees to refuse services to LGBTQ folks based on their religious beliefs. It would apply to any number of government employees. So it's pretty sweeping, and it also redefines what a business can be defined as. So we typically think of a business as an LLC or a corporation, and it broadens a business to include someone as an individual. So if I'm a person, and I have a business, I can redefine my business as an individual. We have a few more minutes. I want to touch on a couple other potential federal pieces of legislation. One, over the last 3 or 4 years, prior to the election, or prior to the Supreme Court rulings on marriage, really for 2 decades, there was an effort to pass something called ENDA, the Employment Non-Discrimination Act. It basically would institute what we see on these state statutes federally, prohibiting discrimination in the workplace, private and public sector, based on sexual orientation and gender identity. After the marriage rulings 2 years ago, the movement was sort of emboldened, and so they decided to expand that and redraft the legislation more broadly to include housing credit, public accommodations, and it's now been reintroduced as the Equality Act. I think it's highly unlikely that we're going to see that bill move in either chamber over the next couple of years based on the makeup of the legislatures and the workload that they have ahead of them. However, there will be debate within the LGBT movement as to whether or not in future years we break those pieces apart and try to do employment, housing, public accommodations in separate pieces. And I think it's highly contentious within the movement whether we even consider that as an option. So although we could talk about this for quite a bit longer, I want to save some time for questions later. I think we're going to see some action in Washington, but most of the activity we're going to see is really on the state level as they debate these religious freedom measures, non-discrimination measures, transgender bathroom discussions, which seem to take on a disproportionate amount of time based on the number of incidents that actually occur in these situations. So expect to see a lot of activity in the states, some activity in the federal government, unless the president decides to tweet about it. So thank you.
So good afternoon. I'm Tammy. I'm a management side employment lawyer from Alabama. So you're probably going, so why are you here? I care about these issues. I think that all people, just like we don't discriminate on the basis of race, gender, religion, all of those things, I don't think we should discriminate based on who people choose to identify, what gender they choose to identify, or present themselves, or who they love. The other reason, though, and being a management side attorney, corporations care about these issues. The corporate America has actually led the fight in many ways on the employment legal side front. How many of you practice employment law at all? Okay, a good number of you. Well, I'm going to breeze through really quick just to give kind of a basic understanding of employment law for those of you who don't practice in the area. The main law that we talk about is Title VII of the Civil Rights Act of 1964. It's been around for a long time. It prevents discrimination and harassment in the workplace on the basis of race, color, religion, sex, national origin. Then over the years, different categories have been added, including age, disability, genetic information, veteran status, and other things. The main agency, the federal agency that enforces these rules, is the Equal Employment Opportunity Commission. And they make sure that, that companies comply with these rules. One of the first fights came with sex discrimination, and back in the 70s, is whether pregnancy is protected by sex discrimination laws. And, first, courts were saying, no, it's not. In the late 70s, the EEOC and courts clarified that absolutely, pregnancy is protected as a subset of sex discrimination. So now the fight really is whether sex discrimination also encompasses gender identity and sexual orientation. And as you can see, in 2016, the EEOC issued guidance definitively saying that in their opinion it does. Now we go back to the election, and Trump got elected, and January 25th, he appointed a new EEOC head of the commission, and it is Ms. Lipnick, who is the only Republican currently on that commission. There's one vacant seat. As of July, the majority on the commission will be Republican, and so it remains to be seen whether they'll still have the same priority on enforcing LGBT rights as the commission has had over the past 5 or 10 years. The Department of Labor is another federal agency that is responsible for ensuring workplace rights, benefits, conditions A couple of agencies you might be familiar with are OSHA, that protects the safety of employees, and Kirk talked about the OFCCP, and this is the agency that protects those federal contractors, the people making sleeping bags for the armed forces. So what happened on Inauguration Day? Well, under Obama, the Department of Labor had issued on their website some information of advancing LGBT workplace rights. On Inauguration Day, that disappeared from the website. So that did not give me warm fuzzies about what would happen next. I really thought that the executive order with the OFCCP that Kirk talked about would be rescinded within the first week or two. I was shocked, and we found out yesterday that Trump said he's not rescinding it, so that was some good news. Other federal agencies that under Obama have done very positive and promising things for the LGBT community are the Department of Justice, and you can see some of the periodicals they've put out. OSHA has put out publications about transgender guidance regarding bathrooms. The Office of Personnel Management, which deals with federal employees. And you heard some statistics about children who are transgender or have a different sexual orientation. That also affects workers. 44% of transgender respondents reported being unfairly denied employment, almost half. 47% responded that they had been discriminated against in hiring, promotion, or retaining their job, and 78% had experienced harassment at work. In the LGB world, 27% had at least one form of sexual orientation discrimination in the past 5 years, not even over their lifetime, in the past 5 years. 27% had specifically experienced workplace harassment, and 7% had lost a job based on nothing other than sexual orientation. So kind of going through the history of some of the laws, Price Waterhouse, back from 1989, the U.S. Supreme Court made clear that Title VII doesn't just protect individuals from discrimination based on sex, but also based on gender stereotypes. Being told if I'm a woman at work that I will succeed only if I dress more feminine, wear makeup, do my hair, wear high heels, that sort of thing. Or being told as a man that, to succeed, you need to be more masculine. You need to play sports and drink beer. Those are stereotypical kinds of things, and that the Supreme Court held, a number of years ago, that's protected. The Oncow decision in 1998 made clear that same-sex harassment was also prohibited by Title VII. When you can't harass because of sex, you also can't harass based on same sex. The EEOC has been very active in this area, like I said, for about the past 5 or 10 years. Macy versus Holder is one of the cases I wanted to mention. And there are two theories on gender identity discrimination. One, it's illegal because sex discrimination is illegal. It's just per se illegal. And the other is based on the sex stereotyping theory that was discussed in the Price Waterhouse case. In Macy versus Holder, a transgender woman applied for, was assured the job, promised the job when she presented as a male. All she had to do was go through the background check. Lo and behold, she went through the background check and they said, we've lost our federal funding. We no longer have that job available. She sued, and because she was a federal employee, the EEOC made that decision. The EEOC ruled in that case that transgender discrimination is discrimination based on sex, and thus violates Title VII of the Civil Rights Act. Similar case with a transgender female as far back as 2008 with the federal court in the District of Columbia. The Library of Congress, again, she was the most qualified person. They told her over and over and over, this transgender woman, that, we can't wait for you to come on board. She'd gone through several rounds of the hiring process. lo and behold, then she tells them, I am in the process of transgendering, and all of a sudden they decide not to hire her. And again, the court said that is literally discrimination based on sex. There have been some key decisions in circuit courts. Smith versus City of Salem held that sex stereotyping violated Title VII as well as the Equal Protection Clause. Glenn versus Brumby in the 11th Circuit, where I am, held that discriminating against gender identity or transgendered individuals violates the Equal Protection Clause. And you might be surprised, Judge Pryor, who y'all all heard about over the last few days, he was one of the 3 finalists for the U.S. Supreme Court, actually concurred in that decision with the 11th Circuit. Kirk mentioned the Religious Freedom Restoration Act defense. There's a key case that is currently going on in which the federal court of Michigan held that the RFRA defense applied here because the EEOC had failed to use the least restrictive means possible to effectuate the purpose of the EEOC in protecting transgender rights. The EEOC appealed this decision in October. Again, as one of the fallouts from the election, there is some doubt of whether the EEOC intends to pursue this appeal. So now the ACLU has filed a motion to intervene on the former employee's behalf. In sexual orientation cases, there are 3 different theories. Again, A, that it is sex discrimination or the sex stereotyping, and then finally the associational discrimination, just as it would be illegal to terminate an employee because they are friends with or married to someone of a different race or someone with a disability. The theory is that it's illegal to terminate somebody's employment or affect their employment because of who they love in terms of sexual orientation or who they're attracted to. There are several cases that, I guess the Baldwin versus Fox was an EEOC case. They definitively held that sexual orientation as a concept can't be defined or understood without reference to sex. So it is sex discrimination. The EEOC versus Scott Medical Health case just came out in November. The federal court in Pennsylvania found exactly the same way, that sexual orientation is discrimination. It's illegal under Title VII. So we are seeing some really promising things that have happened since the marriage case in front of the Supreme Court. Heisley versus Ivy Tech, the 7th Circuit ruled that no, sexual orientation is not protected by Title VII, but they vacated that decision, had a rehearing on December 1st, and those who were at the hearing and who have listened to the recordings of the hearing feel very promising about the forthcoming decision from the 7th Circuit. In Christensen, the lower court ruled that sexual orientation was not protected. The 2nd Circuit heard oral arguments a week or 2 ago, and we feel promising about that decision as well. So we do see a changing landscape, definitely with the courts and even the courts of appeal since the same marriage decision. Just briefly, Title IX, it mirrors Title VII. You can't discriminate on the basis of gender in the university or secondary school setting. Videkus and White were 2 players on the team. They were badgered by coaches. They were harassed. The coach had a team meeting and said, told the team that lesbianism will not be tolerated, affected their playtime, accused them of academic cheating, all sorts of things. The California court ruled that under Title IX, discrimination based on sexual orientation is sex discrimination. Again, what we're seeing more and more out of the federal district courts. Again, associational discrimination is another theory under which LGBT individuals can sue. I wanted to talk just for a minute, though, about corporate America's role, and this has been the thing that has really encouraged me, is it really has just been, and I know Kirk says it hasn't been a fast time coming, and it hasn't, it's taken years, but what's happened over the last 7 years to me has been amazing. In 2008, only 5 companies joined in opposition to California Proposition 8, overturning marriage equality. In 2015, when the Obergefell decision was pending before the Supreme Court, almost 400 companies filed an amicus brief supporting marriage equality. And these are big companies who you represent. These are national companies and other companies as well. I read the amicus brief recently, and it really is encouraging to see what companies were willing to sign off on. Corporations have really been active on the state level. North Carolina, Arizona, Arkansas, Indiana, Georgia, and they've really gotten these states to make changes based on their stance. And you know, communities listen to corporations. Part of this, I think, is because of the Human Rights Commission. Back in 2002, they started publishing an annual corporate equality index that rates company on LGBT equality. And if you haven't looked at this, it really is interesting to see the companies listed. And as you can see, 13 companies received a perfect score in 2002. In 2017, 517. And these, again, almost 200 of these were Fortune 500 companies. Fortune 500 companies, the majority prohibit LGBT discrimination. 50% of Fortune 500 companies offer transgender inclusive health care benefits. So why do corporations care? And I like this quote from a professor at Northwestern's Kellogg School of Business, talking about they do feel that executives feel a moral imperative, but of course they also feel an economic imperative. They care so much about their reputation, both from an employment side and from attracting customer side. We'll talk about this a lot more in the question and answer. I'll turn it back over to Ann.
So Amy, let me start with you. You referred in your remarks to a long line of ballot measures and legal arguments about demonizing LGBTQ folks, and that in the Obergefell case seemed not to work. In fact, it seemed to backfire. Do you have thoughts about why that strategy's no longer effective?
I mean, my personal opinion is, and the simplest answer to me is that people have come out. And I think that Kirk mentioned the Stonewall riot of 1969, and I think since that time, and as policies that have been expressly anti-discriminatory by our government or by businesses have fallen away, people have felt like they can come out, and that now, and so those kinds of arguments about, you know, in the marriage cases, we had plaintiffs who had served in the military. We had plaintiffs who were parents who had adopted kids with severe disabilities. I mean, these were like your neighbors, people who are tax-paying citizens who live near you, or your aunts and uncles or whoever. And so once you have people in America who know a gay person or have a gay person in their family, or that it becomes really difficult to succeed on those arguments that you kind of saw up on the screen that talk about how the social fabric of society will fall apart if we allow gay people access to marriage in a way to protect their family. But I mean, I also want to talk about what Tammy said just really briefly about the private sector, because I do feel like it's really essential to this story that led up to marriage equality. Because really, before the Obama administration, there is not a president in U.S. history that comes even remotely close to doing things on behalf of the LGBT community that he did. And he only started doing it, you know, sort of into his second term. And so, you know, I give these presentations sometimes to people who work with LGBT elders, and those people grew up in a time when the government was firing them for being gay, when they couldn't trust their medical and mental health providers because they were afraid they might civilly commit them against their will. That when you lose that sort of faith in your community, you just cannot be a functioning person. And as the private sector, as medical associations, mental health associations came out and said, gay people do not have a mental illness, this is crazy, And as corporations said, no, we don't care what the government does. We're not going to discriminate against LGBT people. That's bad for business. When that starts to happen, then as much as you think maybe the courts are distanced from that, they're really not. The arguments that the states were making read like, I felt like I was transported back to 1960 reading them, and I don't think it flew in today's society.
Let me follow up with that with Tammy on that. So if some of these more regressive bills pass in legislatures or Congress, how do you think employers are going to react? What's going to happen in the private sector based on what happens in the public sphere?
I think based on what I've seen over the past 7 years, corporations are going to strongly oppose going back in time. Corporations have realized how crucial diversity is, what it brings to the table, how it helps them market to customers. Also, that these laws allow their employees to bring their complete selves to work. They can be a whole employee. They don't have to hide. They don't have to pretend to be someone else or not be present at work. And the perception of inequality at work, whether you're talking LGBT, whether you're talking race, whether you're talking religion, gender, whatever, is not good for any employees. The non-LGBT employees don't like inequality. When they perceive inequality at work, there's high turnover, there's loss of talented employees, there's bad publicity, and the bottom line is companies, stakeholders, and owners make more money when the LGBT laws are there and when they're enforced.
Not to mention consumers who buy their product. So let me ask one more question, and we'll open up the audience. So Kirk, you mentioned, the literally hundreds of bills that have been introduced recently in state legislatures. Two questions for you, really. One, of those, what do you think are a couple of examples of sort of the most oppressive ideas being floated around? And then two, following up on what Tammy said, in the states where these have been proposed so far, there's been quite a bit of backlash. Do you think a trend that will continue? What does that portend for the other states?
Yeah, so we first saw it in Arizona, actually. You remember Jan Brewer, no moderate Republican. She was pretty conservative, vetoed a bill similar to North Carolina's religious refusals measure. And it was done with the outcry of the business community there. Apparently, the message didn't get to Indiana, and Indiana did the same thing. The business community, led by Eli Lilly, corralled a huge coalition to oppose that. It still passed the legislature. The governor signed it into law. There was a major backlash in Indiana, and then they actually came back and amended the measure. But little known fact, even though he's now our vice president, Governor Pence was in real trouble for re-election because of the backlash resulting from that measure, and there was some question as to whether or not he would have been re-elected had he not been chosen on the ticket. Then we fast forward to North Carolina, where the governor did lose his re-election campaign. You could argue that it was really as a result of HB2 because the economy was humming along in North Carolina. Things were looking good for his re-election until HB2 passed. They lost their sports tournaments. They lost scores of conventions. Major employers pulled out projects. And so I think now when I go to Republican Governors Association meetings or National Governors Association meetings, you hear among the staff, these senior staff and these governors amongst themselves, they say, please, we're begging our legislatures not to send these bills to our desks, and they're actively trying to thwart them. In South Dakota right now, there's an effort to pass another bathroom type bill that restricts kids' access to bathrooms. And the new Republican governor there has publicly opposed it. In Wyoming, the Republican governor there, a very conservative Republican, asked his legislature not to send him an anti-LGBT bill. So we're seeing, in surprising places, pushback from even conservative Republicans against these things.
And I should note, one of the things we didn't emphasize when we talk about employers, one of the big changes I've seen in the last decade are professional sports teams and the NCAA, who have now taken positions as employers. So when they talk about no longer being willing to have a tournament there, you have a whole different population who cares about the impact than might otherwise have been paying attention. So let me open it up. Questions? You want to go first, and then we'll do the international?
Yeah, I'll talk about Utah first. So they took it off because, frankly, they didn't want to address the transgender bathroom access issue. And then you also had some institutions that are either partially or wholly owned or controlled by the LDS Church, where they weren't ready to say, we aren't ready to explicitly prohibit all discrimination. So, for instance, in housing at universities, they weren't necessarily ready to say we won't agree not to prohibit same-sex couples from rooming together. So a lot of it has to do with the unique culture of Utah and the LDS Church's influence in a lot of institutions there. And then they also really wanted to sidestep the transgender access to bathroom issues.
I think Iceland and the sort of socially progressive countries were far ahead of us recognizing marriage before we did. The European countries are pretty much on par. Spain, England. And then there's some South American countries where marriage is legal, such as Brazil. And then there's other laws or issues that affect LGBT families. So I think just this week, Venezuela recognized for the first time that the non-biological mother of a kid in a same-sex couple, that she was a parent to that child. So it's certainly, and then there are super horrible countries like Russia and many of the African countries, many of the Middle East countries that have really oppressive, horrible laws that not only prohibit civilly those institutions, but also criminally penalize gay people, including sometimes by death, execution.
Yeah.
Kirk mentioned that it sounds like the Equality Act may be sort of put on the back burner for the next couple of years. And I'm curious what your analysis is about whether the Supreme Court will end up deciding the meaning of sex under Title VII and Title IX. Tammy mentioned the Hively case, the Christensen case. If the Equality Act is going to be put on the back burner for a while, does it seem more likely that the Supreme Court's going to end up deciding that issue? If they decided that sex does broadly include gender identity and sexual orientation, then I'm curious as to how that affects the movement's conversation about breaking up the Equality Act into pieces.
Yeah.
I think it's very likely that the court will reach that question. They could reach it as early as this term in the Gavin Grimm case, which before it is the question of whether under Title IX, sex discrimination includes discrimination against transgender people. And also, as Tammy mentioned, the Hively case in the Seventh Circuit, there's 3 cases in the Second Circuit that present the same question related to LGBT employees. So I think that could be coming imminently, or in the Gavin Grimm case, they could not reach that question because of the deference issue and just sort of send the case back. But I think it's very likely in the next couple of years that the Supreme Court will decide that question, and it could be, it's an essential question for the LGBT rights movement. And Kirk should answer about the ENDA question, but I don't think ENDA has any chance of moving anywhere. And it's been introduced for the last 25 years or something, and it's never passed.
Right. When I was thinking the Equality Act, which is the newer one,
Right.
sort of replacing it. And Kirk, you mentioned that there's a disagreement about should it be broken up and pursue separate ones, or?
Well, this is largely based on political realities. There's really no one in the movement that wants to see it broken up. I think everyone wants to see a fully comprehensive non-discrimination measure passed. But look at the makeup of Congress. It didn't have many. It actually ended up past the House once, and it passed the Senate once in different Congresses, unfortunately. That was in a different time when you probably had anywhere from 30 to 80 moderate Republicans in the House and you had probably a dozen or two moderate Republicans in the Senate, you know, the bodies have become more polarized. You don't have as many Republicans who are willing to vote for these on the federal level as we do on the state level. So, you know, I think that's an internal conversation for the movement to have. I think on the state level, we're starting to see some conversations like that. Should we just pass an employment and housing bill? Should we pass just an employment bill first? Because some Republicans that are introducing these bills are initiating those conversations.
Can I just say one more thing about that, though? Sorry. But I want to make clear that it's not just the LGBT community that's talking about that. We are in a coalition with all civil rights groups because, you know, opening up the Civil Rights Act to amendments by a hostile legislature is a really serious thing to consider, and especially if there's some potential that a broad religious exemption could be added to that bill. So I just want to be clear that it's not just a discussion that is amongst LGBT groups, it's amongst the entire civil rights community, communities of color, religious organizations. We work in a coalition, and those are decisions that are really important and could have these effects on these other groups that are really, really important
I
to
want to
consider.
re-emphasize that. We haven't talked much about it today, but intersectionality, you know, is right here, right now. I mean, so many, whether it's reproductive freedom or immigration, these same arguments are happening. And there's a collective sense of the need to make sure that we're advocating on behalf of everyone, not in silos of advocacy.
If you and the panel have had a chance to look at the new Supreme Court nominees for LGBT rights, can you comment on your opinion of the nominee and where you think he stands?
You know, I think that he is considered to be very Scalia-like, which is not a comforting thing for the LGBT community and for many civil rights communities. And I think that one of the biggest concerns about him is his stance on religion. And we really, I mean, I feel like we could spend an entire other whole session about the religious issues, which are really essential. And I saw Dahlia Lithwick this morning, who I thought was fascinating, and I thought she brought up some amazing points. And it's a very complicated topic. But I think that concern about him, that the language that he used in the Hobby Lobby case when it was in the lower court to talk about the kind of religious exemptions he believes in would essentially swallow up civil rights. And that's a big fear about him.
Right, let me go over here. Yeah.
I believe, I wish Dahlia was here. I believe he's a Protestant. Yeah, I believe he's Protestant.
Yeah. Okay. Aaron?
So there was discussion earlier about how there were two different theories under which LGBT issues were being brought under Title IX for sex discrimination. One is that it was per se sex discrimination. The other was it was based on gender stereotyping. Is there a particular theory that you're pushing for and that you prefer that the rules be under, or are you just happy for results?
Tammy?
I mean, I think we're happy with the results at any level. However, I think it has to be because of sex. I mean, it seems to me that you want to go back to gender, whether you're talking, you know, transgender or sexual orientation. How is it not because of sex? So it seems to me that that would be the preferred method. Do you disagree?
Yeah, I mean, I think the theory about gender stereotyping stems from the Price Waterhouse case, which Tammy talked about, which was basically Ann Hopkins, who was supposed to be made a partner in her firm, and who the other male partners said basically should go to charm school, that she wasn't feminine enough, and denied her the partnership. And so that was when the Supreme Court said it's not just about the traditional biological differences between men and women that is covered by Title VII. It's also any sex-based characteristic. So that includes stereotypes about people. And I think for transgender people, some of the cases that talk about this, what they say is that being a transgender person is per se all about sex. Like, that is the definition of a transgender person, that their gender identity differs from their sex assigned at birth. And so if you're firing someone because they're transgender, that is sex discrimination. And I think, personally, that's the clearest description of what it is. But certainly, it's also sex stereotyping. It's the belief that that person, if they are born a male, should not transition to become a woman, that you don't believe that that is something they should do, and that is a sex-based stereotype about that person.
I think we have time for one more question. Somebody didn't get to ask one yet.
Would it be possible just to comment on private employer, any state, doesn't matter, just what the 3 best practices would be for that employer? It seems to me that in all states, the bathroom issue just ultimately came to the forefront, and the best practices that can still happen sort of fell to the backside because everything came back to the bathroom issue, bathroom issue, bathroom issue. You know, I'll throw one out there, you know, checking all your policies, making sure that there's a specific reference to sexual orientation and gender identity in the bullying policy, the discrimination policy, the sexual harassment policy might be one. Could you comment on others that aren't the bathroom issue that we should be sure to be focusing on?
I mean, definitely providing benefits to same-sex couples on the same basis as opposite-sex couples, so you cover their spouses just as you would an opposite-sex married couple or their children, regardless of whether they are the biological or the non-biological or the adoptive parent of those children. I think that having a policy in place that allows employees, if they're going to transition, to change the gender marker on their employment documents is really important. I think, you know, being ready to consult with an outside expert if they do encounter a transitioning employee, to talk about how to do that in an effective way that is also lawful. And I think having basically just being, I mean, I think the example you gave of making it explicit in the policies is really important, and it sends a message to all of the employees.
Tammy?
And I would add that companies shouldn't be afraid to talk to the employee. I mean, when they, you know, are transgendering, the company should go to the employee and have conversations about how that should be rolled out, whether they want to announce it to their coworkers, what pronoun they wish to be called, just having conversations about it. I think too often employers are afraid to talk to the employee about it.
I'm going to add one last best practice, and that is employers should be advocates. So I think we've found that companies have been very forceful in some of the states like Indiana, Arizona, North Carolina, and they've had an impact. And they shouldn't be afraid to speak up when their legislature or their governor is going down the wrong path. You know, these really do have harmful effects on businesses and their economies. The folks at Eli Lilly were very explicit when they testified in Indiana about employees that decided not to, or potential employees that decided not to accept jobs in the midst of that debate before it even passed. And it really does color the potential employees' reputation or perception of that state. So I would say that you should encourage your employer to weigh in, whether it's behind closed doors on a call with the governor or a state legislator or more publicly.
And I would add to that, who's on their board of directors, who's in their management ranks, and who are they hiring across the organization. You know, if they don't practice what they preach, the employees know that and the customers know that. So those are all important markers. And I know we are out of time, and I was asked to save a minute for logistical announcements. Also, if you all didn't get the handout at the beginning with terminology and you'd like that, we have some extra ones up here. And for those of you who can't read the bottom, can you all read who made this statement that's on the slide and when it was made? Okay. Huh? That is at the entry to the Holocaust Museum in Washington, D.C. So I just found it quite remarkable seeing that, that both how far we've come and how far we have not come. So join me, please, in thanking the panel for their presentation.